First of all, welcome everyone and welcome to our guests out here today. And I was just looking, I know Richard White, there it is. Jeff, you just want to take a roll call to officially.
So sorry, 1 second.
Oh, yes, it's me.
All right, sorry about that.
Chair Stern,
Yes,
Vice Chair Burdick. Present. Richard Weiss,
Yes.
Ben Sorensen.
Yes.
And Harrison Graham Williams.
Yes.
so we do have a quorum. Normally we do the pledge of allegiance. I'm looking around the room and the flag isn't here. Any suggestions? Do you want bypass? Do you want move forward? Okay. First thing was the approval of the March 2nd, 2023 meeting minutes.
So moved. Second. I just had a question.
And I do have a question. Go ahead, then.
This was, it's probably not gonna change the minutes, but just follow up to always, the question we had was the subcommittee question. Possible.
I haven't looked any further, but I do not think that's possible.
Yeah.
I don't think this time, yeah. I don't think there's the authority.
Well, I think the question really is the approval of the minutes. So is there anyone here that has any comment? I have, because I do have one comment on the minutes for clarification. The only question was, I thought that we had Richard Weiss down here for preparation of this meeting. But I really thought that the intent was to have Richard be our liaison for all the meetings to work with staff. If that's the only clarification I want to have the minutes.
It depends whether you like the agenda.
Far so good.
I just think Richard has the time that and knowledge and experience. So that was the only clarification that I thought was understood the last time. Other than that, anyone want to move to approve the minutes?
So do
Or
you
move
want
to
to,
attend?
Yeah, we got
Make
the
a motion
first and
to
second. Oh, all right.
Are you calling for an amendment to the motion?
Well, no, just calling to amend the minutes of the meeting to clarify that point, Richard Weiss being the liaison for all the agents.
Then I'll withdraw my motion so that we can do the,
I'll move.
I'll second the amendment.
All in favor?
Aye.
All opposed?
Move the minutes as amended.
Overview of the local ethics provisions, and Richard, since you worked on that, with staff's
I'm
point.
gonna take the first, so.
I think you need the motions.
Oh, to approve
As
the
amended.
final minutes. Okay.
Once again, I'll move the amended minutes.
Second.
All in favor?
Thank you.
Aye.
Aye.
Richard, do you mind just do a quick overview of the local ethics provisions and then we introduce our speakers that.
Well, I'm gonna,
So kind of-
I defer to the speakers. But I tried to, with working with the staff, we tried to give you, as much information as we could. The issue, the piece that's not here is the state law, which is just a lot more. So this is just Broward and Fort Lauderdale. And so I think the direction I got was that you wanted sort of an overview of the Broward County ethics provisions and the Fort Lauderdale provisions, and then a discussion as to whether we felt that there was any charter work that needed to be done in this area. So that's sort of what I tried to lay out.
So we have reminders. Nick Whisper, Christy Potter. Right here. And you want Carol and Jody.
Jody Bruce is great.
And Jody's the general counsel for the Inspector General for Broward County.
I'm actually in Spanish.
You are now. Thank you.
First week.
First-
So you can see how long ago this agenda was prepared.
We kind of got rained out. Yeah.
Judy, do you want to set the table?
Yeah, please do.
We'll go, Kristen's gonna join me, so we'll go down there.
No, we're fine. I mean, unless you want us there.
And while they're setting up, just for those of you that don't know, you know, Rudy has been the county attorney for how many years now?
But coming on 6.
6 years, but prior to that, he was the deputy over there since the 90s.
I got to the county in '99, and I was the chief appellate counsel. Also very active with this ethics code for better and for worse back in about 2010. And I became chief deputy county attorney in about 2013 and became county attorney in 2017.
And Kristen worked in the state legislature with both Tim Ryan and Nan Rich, and then she worked with Tim at the county and got the law degree. And went to work in the county attorney's office. So her knowledge of legislative as well as county government, municipal government, state government, speaks for itself. Nate is assistant county attorney. He's also the expert here on election laws, which was really important since we do contract with the county, with the supervisor of elections. And he's very familiar with the changes and some of the things that came up last year, his knowledge, etc. That's very important. So if we want to start with, really?
Thank you, Judy. And I'm very fortunate to have my 2 colleagues here. I actually used to handle a lot of election work as well, starting with the 2000 recount. And over the years, I've found people who both on the election side and ethics side can do it better than I can, as I will about to reveal through my comments. I've forgotten quite a bit of the details on ethics. Kristen is our lead ethics lawyer and handles things on a day-to-day basis. But these questions that we get are very, very complicated often, and the stakes are high. Our advice is conservative, but we, as Harrison can attest, because he hears some of our advice here and there. We want to make sure our elected officials and mostly senior employees, but all employees stay out of trouble. When we have questions, we'll call the state periodically. We also will speak with Jody and now her wonderful counsel team. We're very appreciative to have an Inspector General's office that's very collaborative, that I have always said, in my opinion, is looking for compliance, not gotchas. Which is very, very helpful, makes our job easier, and we try to keep things, code provisions as clean as possible, in part to make their job easier as well. So I was asked to speak about the history of our current ethics code, how we got there. And I'll also just briefly mention, as Richard mentioned, that most of what we deal with is under state law. Chapter 112, Part 3 in particular, is the state ethics code for public officials and employees. And it's complicated. We have provisions, as we're allowed to do. I think it's 112.326 allows us to develop more restrictive provisions, provided that they're not in conflict with state law. And for the lawyers in the room, conflict is always a very interesting question. Conflict is normally narrowly construed to try to let both provisions proceed, but in the ethics context, whether there's a conflict or not, and we're allowed to have a provision in our code, or for what I'm about to say in a second, whether you can have certain provisions in your code or charter, really depends on the specific language that's at issue. And sometimes the phrasing of the language, even though the substance might be the same, with alternate phrasing. The reason I mention it's important to you is under the county charter, the county ethics code, which is an ordinance, prevails over any conflicting municipal ordinances. So if you're doing our interpretation of that is it means ordinances and charter provisions. I'm not going to tell you that we haven't had a city here or there take exception to that. But so far the peace is kind of held on that point. There are only a few areas where the county sort of preempts the controls over municipal regulation. This is one of them. So if you're going to want to do something, you have to at least address the issue as to whether it's in conflict with our code, whether you're doing something more stringent or less stringent. And less stringent doesn't really help because at least when dealing with elected officials, you're going to be subject to our code anyway. So how did we get to where we are now? And I don't know how often you all have reason to look at our code. Kristen looks at it every day, multiple times. I don't look at it as much since Kristen has become lead counsel. But back in, I think, 2008, round numbers, there was a county charter review commission that, because of a lack of progress, I'll just say, or lack of perceived progress in the county enacting certain ethics provisions, put something on the ballot asking the voters whether it should create an ethics commission for the primary purpose of drafting a code that the county commission, under the charter language, would have to approve, just thumbs up or thumbs down, couldn't modify. And if the county commission didn't approve it by some date in 2010, that would have still given us time, I guess, to get on the ballot. That year would have been, right? Then it would have gone to the voters to basically create an ordinance, is the way that it was framed. We advised the board, there were a lot of provisions in the ethics code that we thought were, frankly, still believe are very problematic, mainly having to do with lobbying, First Amendment rights. There were other provisions in there that were, what's the word I'm looking for? Downright silly, a good word for it. In fact, Judy, I know that you've always been close with Lois Wexler, and Lois Wexler proposed an amendment at some point as she was being termed out. It was such a hot issue and no one wanted to touch it. So when she was leaving, she had good status. No one could question whether she wanted it to apply to her. And she proposed some amendments that we still had trouble getting through, but things like, can I take a bottle of water? I'm here as a county official touring a runway in Fort Lauderdale's airport. It's the middle of summer, it's 95 degrees out, and I'm thirsty. Can I take a bottle of water, or do I have to repay you within 90 days? Before the Wexler amendment, you had to repay within 90 days. Because if you pay something back within 90 days, it's not a gift. Now you can take a bottle of water, really almost any type of water. We haven't quarreled with you yet as to whether.
It's not really strong water.
Oh, it's just not really strong water. Very good. So the board passed the code 9-0. They didn't take our suggestion, even though I was just the chief appellate counsel at the time. I was the one who was going to have to defend the litigation that we were expecting. So it was my recommendation that they change very substantially the lobbying provisions that are in there. They didn't listen, and they were actually in there until about 4 months ago. I think back 6 months ago, back in December. This year is really moving fast. When, because of a change in state law, based upon a constitutional revision and the implementing statute, they enacted incredibly broad lobbying prohibitions. For strategic reasons, we modified our code to basically track the state code, expecting there to be a challenge. There was a challenge quickly. The courts enjoined the state law. So right now, our lobbying provisions are very much in flux. But after our board passed this in 2010, we went through a series of amendments, some charter amendments, some extensions to it, including extending it to cover municipal elected officials. And to make sure that we could do that, and municipalities, when they say misery loves company, it was a miserable code. It applied to the county, and if it was good for the county, I guess it was good for everyone. But to make sure that the municipalities, because under the charter, unless it was one of these, at the time, I think 3 areas where the county controlled in the event of a conflict, ethics wasn't one of them. a charter amendment was proposed, approved substantially by the voters, and that gave the county the power to impose these same ethics provisions on municipal elected officials. But there have been a lot of changes over the years. I think on page 1, and I'm sorry, am I stealing your?
No.
Okay. So on page 1 of the little 3-page memo we've handed out, this lists all of the various code sections. Our ethics provisions are scattered into various sections. I mean, you could argue that cone of silence is not really ethics, but just we tried to capture pretty much everything in here, so you can take a look at it while you're going through your process. If you get to page 2, it basically explains what I just went through, which is how we got to our current code, all of the bells and whistles and the stuff back in 2010 and subsequent amendments. And then if you get to page 3 of only 3, thankfully, this lists, I believe, all of the amendments to our code since 2010. And you can see they picked up speed a little bit in 2017. That actually preceded me as county attorney, but I had maybe a little more influence. And I've been encouraging some changes here. I think we can afford to have some common sense changes. This is not meant to be a trap. For the unwary, this is meant to be something that leads to good government and transparency and permits investigations if something should be looked into. I mean, it's a legitimate function for people to investigate, to make sure that people are doing the public's business honestly and not profiting themselves or somebody else that they may choose to favor. And so we really focus on clarity. If you read the code right now, you might not think that we've hit our mark, and I'm confident we haven't. But we expect to, after the lobbying litigation that's going on right now over the state bill and now ours in a sense, although we're not a party, but because we adopted those standards, once that's resolved, probably early next year, best guess, it's up at the 11th Circuit right now on a preliminary injunction. Then we're going to look at this holistically. We're going to meet with, I think the Broward League of Cities has a subcommittee that is focused on ethics. They've been very collaborative with us on this, and we're going to look to, and we're going to invite Jody and our predecessor, John Scott, who just retired after 12 years of great service. Do not chime in on policy decisions. They've made that clear. They'll give us their thoughts on things, but they're going to leave policy to the policymakers. But they want to make sure that it's clear and enforceable, and that there's sufficient transparency that they can do their jobs as well. So we'll bring all the stakeholders together, and I don't know how long your charter review lasts. I don't know when if it sunsets at a certain point. No. So maybe next year, if you have us back, you'll see another line added onto here, 2023, 27 or something, where we have our 2024 something where we have a new ethics code, or at least a substantial revision to the ethics code. So that's my take on the history of how we got from 2010 or 2008 to now. I'm going to turn it over, Kristen Moore for just questions. I really brought her, not Judy. I saw your questions as I was driving over, and we don't, so we don't answer.
Right.
We advise our folks. We're happy to answer questions about our code, but not necessarily the application of the code to a specific fact pattern. Part of the reason is, as recently as even a couple of months ago, I answered something off the top of my head and I was wrong about it, and I had to apologize and make it right. I don't like being wrong, so I thought I knew the answer. So we fixed it in time. But I like to vet everything. We look at these things very carefully. We like to sit on it for a little bit, and again, we will call in the state or even municipal colleagues or the IG's office if we're having real troubles with it, because we don't want to give one opinion. We can protect our officials under our code. We can insulate if the facts are provided and adequately disclosed and all that. We can't do it under state law. We just are giving an advisory opinion. So we like to be extremely careful, including with fact pattern.
I think it was important that the public be educated, because they had no idea that there's a county charter that oversees municipal individuals.
Yes.
And therefore, things that those of us that have been around, especially through this whole, and I was there through everyone's meetings when the county code was created. Those of us that have that knowledge sit there frustrated. And then we get the phone calls from the public saying, how could they be doing that? And we don't see in your charter, and I'll go, well, it's in the county charter. So I think it's important this year, we do as much education to the public, which is why we've asked for this to be on YouTube and why we've included always the Council of Civic Association to attend our meetings here, so that they realize there is a county charter that does govern over municipal officials. And it's really good. And Kristen and I have been back and forth over the years when she was in Tallahassee. And you may want to add some points to it, since I remember when Tim, when he was in the legislature, came up with some of the ethics codes even there.
Sure. Now Commissioner Ryan, former Representative Ryan, that dealt more with what's called the Hatch Act, or the Florida version, which is the Little Hatch Act. That it's actually in the election code, but I think kind of in the public's mind would fall under the rubric of ethics. And that's essentially, you can't use your office to try to influence the outcome of an election. And I think I read in your backup materials, there's a similar provision, and I don't know if it's I think it's in your city code that goes to that effect.
And some of the issues that I know from the county side, the forms that are required for elected officials, so that there's transparency, so gifts, receiving of gifts, and as well as solicitation for charitable contributions or events, that forms have to be filed.
Right.
And that should be followed through with the cities, if I understand.
A lot of that, and Kristen could cite chapter and verse, and I'll stay away from that, but a lot of the forms are, for example, gift disclosures are state forms. Form 9 and Form 10, I guess, Kristen. And so when we do ethics training every year with our commissioners, when we haven't brought it today, but we have a two-sided sheet, I think, that we hand out, and on one side, it lists the state disclosures that you have to be concerned about, including the big one, the Form 6. I don't know if they're doing that for city officials. They were talking about it.
So happy the legislature finally did that for municipal government.
They did pull the trigger on the Form 6?
Six.
Oh, boy. Well,
It's wonderful because the county commission does it, the state legislators do it.
it's,
So there's no reason why city officials shouldn't
No,
have to do a Form 6.
it's very intrusive. I mean,
Just hire CPA.
yeah, it's true, but there are some people who may not have the resources to do it. I don't know. I mean, look, I won't get into that, but on the county side, we have a number of things that are stricter than state law. So we don't have currently, there is, I guess, something in there for gift disclosure. If you can take under our code, if you accept, I guess, certain charitable tickets, is there, so there's one limited gift disclosure, I think, and actually Jody is way more expert on this than I am. But we have maybe 6 or so disclosure forms. We're creating a new one as we speak, because we're going to have an item coming up to do another small tweak to an interim tweak to our lobbying provisions on May 23rd. And we try to keep the forms as simple as possible, but one of the things, and Jody, I don't want to embarrass you, but one of the ways that I knew we were dealing with somebody who was doing that, part of the Inspector General's office, and now the Inspector General, for the right reason, is one of the first calls I got from her was, some of your commissioners didn't timely submit certain forms. They weren't looking to throw the book at them. They were saying, we want compliance, we want education, we want, this not to happen again, ideally. So just a very practical approach. And, there were some things in our code, there were some things in state law that are not really intuitive. And I think that at the county, we have 54, 55 lawyers in our office, including 4 or 5 lawyers that have pretty good experience with ethics. So when our commissioners have a question, and a lot of times these things come up, very, very closely before it's at issue. I had someone ask me about a voting conflict on the dais, that I didn't tell you about that this week, was not, fortunately. But, we have to answer these things quickly, but, if I'm at a meeting, I can call Kristen or I can call 2 or 3 other people. She's my first call to get it answered. But, cities, especially smaller ones, may not have those same resources. And so, part of when we draft this, we try to revise it. We're going to try to make things as, plain English, simple, as intuitive as possible. Because again, everybody knows that you're not supposed to take a bag of cash from somebody. I mean, which some of those things from years ago, led to the creation of our code, some really bad judgment by some people years ago. But some people may not understand that, I can't take a present from my closest friend who I've known for 30 years we've always gotten exchange presents because that person happens to be currently lobbying on a particular issue. Or may not know, and frankly, I had forgotten. I don't get a lot of expensive presents, is the good news, but or bad news. But I got one when I turned 60 a couple of years ago, a nice pen, and I said to Kristen, I got a nice pen, and she said, "Oh, you have to disclose it." I'm a Form 1 filer. I wasn't even sure I had to disclose gifts over $100 that I received, but I do, and I'm county attorney and someone with a lot of familiarity with ethics. So it's important to have clarity. It's important to have consistency, and those are the things that we will strive for as we continue to work on revisions to our code.
If my memory serves me correct, one of Sue Gunsberg's things were if the public doesn't have access to an event. Right? And Kristen, do you want to speak off that? You recall what I'm
Sure.
talking about?
I think perhaps you're referring specifically to charitable fundraisers. So under our code, and it tracks with the state ethics, code of ethics in terms of under the state law, you're allowed to attend a charitable event as long as you pay, and assuming that the charitable organization is a contractor or vendor, principal, or lobbyist. You're allowed to attend that event by merely paying the actual cost of whatever the cost to the charity is of putting that event on. You're not required to pay the embedded
Full ticket, but
the embedded charitable contribution in the ticket price. But under our code, it actually must be an event to which tickets are available to the public. And even then, if you pay the reduced rate, and this applies to elected officials, you must repay the cost of the event within a certain time frame. I want to say it's 30 days, and then within 15 days, you have to disclose it on the form that we've created.
and it had to be something where the public has the same access
Correct.
to the event.
Correct.
So if it's a private scenario where the public doesn't have the access and only you, then you can't do it, correct?
It's gonna
How does that
depend
work?
on some specific
You can
facts
always
there.
compensate.
You can always pay your way
Yeah,
in.
that's- and then you have to pay for the expense. Yes.
And then the question is, always how much do you have to pay? And there are different provisions and, so what Kristen cited, what you can not pay the embedded charitable contribution.
Right.
If I think, correct me if I'm wrong, but if the ticket comes directly from the charity.
Correct.
But if
right,
a lobbyist
right.
wanted to give you that same ticket, and let's say the ticket's $250, the actual meal, entertainment, hall rental, all that stuff is $100, and $150 is the embedded charitable contribution. If the charity gives it to you, you only have to pay $100. If a lobbyist gives it to you, you have to pay $250. And people may not recognize that distinction. They're not intending to get a gift they can't take, but then they find out when they vetted with us, if they act before they ask, that they have to pay $250 and not $100.
And that's why, and it's because that's why we're hesitant to answer specific questions, because they are so fact dependent. And, for example, under state law, an elected official can accept up to $100 from a lobbyist, vendor, contractor, or principal of a lobbyist of their governmental entity. Whereas for us, it's $5 or, you know, all the water you can drink, but, and I mean.
And that's for the cities as well as the county.
Yeah.
Correct. And so it's a very different, you know, you have to look at the interplay between the state law and the county ordinance, and who, you know, we have flow charts starting out of, depending on who the donor of the gift is, and it sort of spirals in complexity from there.
Under state law, if a constituent who's not a lobbyist or a vendor, and again, you're always going to jump in and correct me if I make a mistake, because she knows the specifics better than I do. But if a constituent is very happy with a commissioner or a reporting individual for the most part, and they're not a lobbyist or a vendor or a principal of a lobbyist, they can buy you almost anything. They could buy you a plane. or an
As long as
airport.
there's no.
Yeah,
quid pro
as long as
quo.
they're not expecting you to act a certain way based upon that. You're not
Correct.
giving them anything for it. They can do that. Under our code, there have been times when, you know, grateful constituents have bought, you know, like flowers for somebody, and I buy flowers once in a while, and I know that's over $50, which is our limit. So we've had to say, okay, display them in the common area. You can't do it. Try to return it. If you can't reach them, display them. If it's food, they'll bring it over to a place where they need the food. Or sometimes just leave it, you know, out where the public can eat it. You know, we'll get these calls at the last minute. I used to get them before holidays. You haven't gotten these recently. But you know, but on a Friday, just before Christmas, you know, somebody just dropped off this perishable item. I can't reach them. What am I supposed to do? You know, do I let it sit here? Do I throw it out? And we'll say, well, you know, all you can do is the best you can do. So, you know, you're passing, you know, some charitable place, some food kitchen, something on the way home, you know, do that. And, you know, if somebody picks up a check that they couldn't pick up, you know, send them a check, you know, that they pick up the dinner check, and then they call, oh, so-and-so took me out to dinner. But, you know, we should check and make sure they're not a lobbyist. So they don't lobby the county, but they're at it, they might. And then we say to them, okay, you have to cut a check back. You know, you have to do it. Sometimes you have people who are extremely stubborn and won't accept something, and we'll say, you know, if worst comes to worst, donate an amount to charity if you have to fix it. If it's a company that you can't find, you don't know who donated, somebody left something. You know, because the optics of this are important too. Sometimes you can't fully comply. You strive for full compliance, but it's kind of like the sunshine law. You want full compliance, right? That's easy enough to do. Public records, Paul, I don't know about at your place. I mean, I don't know anybody who's 100% always on public record. Someone's gonna inadvertently, you know, erase something that wasn't their personal note on something, or strike through something, or forget to file an email, or delete a voicemail that they got by mistake. I mean, I have to remember, and I try to. Unfortunately, we don't get a lot of voicemails these days, but forward a voicemail to myself, and then I save it, because otherwise, if I keep it in my phone system, it clogs the system, and I won't be able to get voicemails after a while. But you know, some of this is practical as well. And then if you keep seeing the same fact patterns, and you're having to make practical judgments, and you have the ability to step in and amend a code so that people can actually fully comply, as opposed to just do the best they can under these circumstances, then you try to step in and make those changes.
And as an example of that, where we made some changes in the code recently, oftentimes elected officials, you know, support other candidates' campaigns for office, and they allow their names to be used for fundraising solicitation. So instead of every time an invitation goes out, you know, for Joe Schmo for dog catcher with your name on it, we revised that filing requirement so that it's one disclosure, you know, per candidate until the next election, or 2 years, or next general election, or 2 years, whichever comes first. So in order to, you know, not play gotcha where we want you disclosing constantly, I think, you know, we realize the takeaway on that is we want to know, you know, who you're raising money for, and one time per election is going to meet that goal.
Questions?
Yeah,
Yeah.
thanks, Chair.
You mentioned the state law around lobbying is a little bit in flux, and just give us a little bit of color there. What are some of the topics that?
Sure. Thank you. So, you know, the county in 2010, when it enacted its ordinance, had what we consider to be the broadest lobbying prohibitions anywhere, certainly in Florida. The prohibition was on elected officials, immediate family members of elected officials, their office staff could not lobby any governmental entities within Broward County. And people were upset about it. Give you one example that we avoided because the individual went to the legislature, but we had a city commissioner, Jared Moskowitz, whose father was a prominent lobbyist, as we all know. And once they passed the code, technically, Mike Moskowitz, who owed nothing to Jared, I mean, Jared didn't make Mike helped make Jared. Mike wouldn't have been able to, to lobby. So we had some problems with its breadth even back then. What the state passed, it was a constitutional amendment in 2018, 2018, and then implementing legislation a little bit after. Even they waited a number of years to come up with implementing legislation. Any elected official, okay, so City of Fort Lauderdale commissioner, who let's not even look at Fort Lauderdale. Look at a really small city that I don't know, they're getting $500. So I don't know what they get paid. They have very small agendas, and you really want to get a high quality person in there to serve. It's not lucrative, and that person happens to be a lawyer or a lobbyist. Under state law, that person wanted to lobby a school board in Escambia County. They couldn't do it. They wanted to lobby federal agencies. They couldn't do it. It broadened. Ours was just within Broward County, and frankly, I thought that was too broad. I was concerned with some of the restrictions on relatives, especially when they were independent, like Mike Moskowitz and Jared Moskowitz, and also concerned with lobbying, what they call lobbying across. Some people thought lobbying down, county commissioners shouldn't be able to lobby municipalities because they do favors for the municipalities, or they have discretion to contract with them. But lobbying across, a Parkland city commissioner couldn't lobby somebody from Hallandale Beach that they've never met. We had problems with that. Now you can't lobby, I think federal agencies anywhere, and it's enjoined, it's temporarily enjoined, but someone's gonna have to explain to me, because remember, we're dealing with protected speech rights now. I mean, there's strong First Amendment protection for lobbying. So what is whether it's under what's called intermediate scrutiny or heightened scrutiny, and I think it's entitled to, to more of a strict scrutiny. Why is it, what's the danger of somebody who is an elected official in Broward County lobbying a school board in Escambia County? What harm, what quid pro quo are they worried about? What optical problem are they worried about? So the breadth of it is just stunning to me. I gave an opinion that I thought it was unconstitutional. And we have an internal memo from people far smarter than I am who thought it was unconstitutional. And the federal trial court, through preliminary injunction, thinks it's unconstitutional. Second thing that it does that I also think is a problem is there's a 6-year revolving door ban. So if you're an elected official for Broward County, under the prior iteration of it, I think it was 2 years, you could not lobby the county for 2 years, but after that you could. Frankly, after Citizens United and Gilbert and some of the other First Amendment cases, even 2 years was, in my opinion, a problem, and it was invalidated at least in one federal trial court. Our legislature, made it 6 years. Or I guess the constitutional or the voters, but the Constitutional Revision Commission put it on. I mean, I don't understand it. Now, who knows? Maybe you could say, well, a term of office is usually 4 years, so maybe 4 years is the right amount. If you're out for a term and then you come back and you want to lobby, maybe that's okay. But but these are provisions that we don't think exist anywhere else in the country. So it really doesn't surprise us that at least through the preliminary injunction stage, a very good federal trial court thinks this is problematic.
And to clarify, the part of there's the two parts, the 6-year revolving door ban, there was a challenge to it. The court did not find that the party bringing it had standing. So that is not currently enjoined. It's the sitting elected official lobbying prohibition that's currently in litigation.
Thank you.
And just to make sure that it's clear for the record, how much of the county's ethics requirements exist in the county charter versus how much of it is established by and only by ordinance?
Yeah, most of the substance, the vast majority of it is ordinance. The charter, it's even the Inspector General's office was part of the initial ordinance when this came up in 2010. It was split off and it was put into a charter provision. And then there are, Kristen, we have what, 2 or 3 other charter pieces like the county priority or controlling over municipal.
One interesting quirk of our charter is the super duper voting conflict procedure where under state law, if you're an elected official and you have a voting conflict, you are required to declare the conflict ahead of time, abstain from voting, and then file a disclosure on a state form. Under the county charter, and if you have an apparent conflict, you still can declare a conflict, but you're not legally required to. Under the county code, if you have an actual voting conflict, you must leave the dais. So if you ever watch county commission meetings, you may wonder why they have this sort of theater of someone walking out of the room and literally, like, as soon as they're out the door, they move it and pass it, and it's, then the person runs back in. That is in our charter, and that is one of the rare things in the charter, but my boss is correct that it's almost entirely within ordinance.
Given the nature of the fact that county supersedes municipalities, what's your suggestion or your view on how robust city ethics code should be, given that can there be significant deference to the county? Should cities be just as robust, reflecting the county provisions as well? What's your guidance?
I mean, it's there are a couple of schools of thought in drafting. I mean, my preference is when we draft is not to have redundancy. So we don't like to restate things in our code, because then if they change in state law or federal law, we have to change them also. And we're stuck with them anyway. I mean, in a county like Broward, which is fully built out, which, one part of the county is, I know we're all different cities and we have our unique personalities as cities, but it's pretty similar. To me, the most efficient thing would be to have one code, being the county code. And if there are problems in the county code, which I'm telling you there are, but I may not know all of them, and we do have a very good relationship with the municipal attorneys. We discuss these things. We can prepare revisions to our code. That might also have the advantage of having one uniform code for the Inspector General's office in terms of enforcing it, and also lead to less confusion, because if you have a municipal official, a county commissioner occasionally will go out to dinner with a municipal elected official, and they may even go with someone else, and one rule may apply to one and one may not apply to the other, and that may lead to an inadvertent violation of the rule. So my thinking, and I'm wrong exactly 50% of the time, is so you can get no clue as to on this one, but I would, were you my client, and you're not, and I'm not trying to step on anyone's toes. I just think in this subject matter, at least tread lightly, and if there's anything you feel needs to be in there, coordinate with us, just so to maybe get our opinion as to whether it's permissible or not, given the charter language and
That was the original intent when this came about. And the public, like I said, the reason that these discussions, public has no idea that there already is something in place that governs over ethics at the city level.
If I can just add.
Absolutely.
The code of ethics in the county code, it's called the Code of Ethics for Elected Officials. And today, we do not have a county code of ethics for employees. And so to the extent that you have employees with municipalities and you want to regulate their ethics beyond what the state code does, then of course. Sure.
But is there a state code of ethics that applies to municipal employees?
Most definitely. So the state code of ethics for public officials and employees applies to the city of Fort Lauderdale's employees. Most definitely. And it is comprehensive and
we do actually have, in chapter 26, we have a code of ethics for employees. It's not as,
But for county.
only for county.
Yeah, we
employees.
didn't extend, and I should have been clear with that. They extended it to elected officials only.
Right.
Didn't
Not
want
to
to step on,
municipal employees.
exactly, didn't want, figured, you know, you guys have your own unique situations and you should regulate your own employees, but that is something, because there is no county code on that, as Jody just pointed out, there's no conflict. Our code, I wouldn't necessarily look at our code as a model to consider adopting. There are parts of it I don't like at all.
For employees.
For employees, yeah, it's so just, for example, and we had one the other day, and I don't get involved in a lot of the questions for employees, but employees, so Commissioner was very happy with some employees who went above and beyond, no question, with the flooding. And you guys, I'm a Fort Lauderdale resident, you guys did a great job, and we had some people who did a great job too, and the commissioner was incredibly happy and wanted to take them out to lunch. And there was a lot of disagreement in our office as to whether that could happen. So that shouldn't be a problem, my opinion. A grateful, you know, I would think the commissioners would like that, actually. Sorry, I'd love to take you out to lunch, but I
But I
can't.
can't.
The lawyers will let me, you know, but this one actually wanted to take them out to lunch, and I think did not on our advice, just so the employees don't get into trouble.
Because under our code, a county employee is prohibited from accepting anything of value if it's given in their official capacity.
And I think, and I think we built in, but I'm not sure if it's even in there. That, so if, because I used to go to meetings sometimes at cities, and Richard, I used to meet with Jamie once in a while in your conference room there, and you had way better drinks than we have in our.
Very good.
You had cans of soda and all sorts of stuff. And so I think that if they're offered, if they're available generally, you can take it.
Correct.
But not otherwise.
There are exceptions, but it's
Limited.
they're very.
With Lois Wexler at the time, because she was on the school oversight committee. And she was like, you mean I can't go to the school board meeting
Mhm.
and have something to drink that they're offering me?
It's-
And that's, that was really what started. Jeff Newton told her to go find a new friend, because we went to high school together.
Right.
And she says, what do I do? And he says, go find a new friend.
Actually, I told her, I said, good news, you could buy Judy all the gifts you want. She just can't buy you. She didn't like that. No, she was okay with it. No, she was a stickler, you know, she wanted to make sure she complied, but she put in a lot of these common sense changes. Because it hasn't hit employees. We don't talk about it too much, but the employee code can use some revisions as well.
And you had the issue too, because you had Eileen Lieberman on the commission, and her husband Stuart was the city attorney in Sunrise. So then there was some questions about that and the interest of her vote at the county when it came to the city of Sunrise. And with Sue Gunsberger, who brought up the issue of Bill Brown was explaining to him, a lobbyist is anyone that's an advocate. And Sue said, well, wait a second, we better remove homeowners, because every time I go to the grocery store, I get stopped in Publix. So HOA and homeowners got removed from having to be registered, but anyone else that's an advocate had to register as a lobbyist.
And if you think about it, because our code also had the problem of capturing both compensated and uncompensated lobbying. Under some of the First Amendment jurisprudence as it's been developing, saying some people have speech rights based on their identity and other people don't, like homeowners associations and certain charities. It's a big problem, which is another reason we went away from our code in the interim while this whole state lobbying issue is being resolved. This is protected First Amendment activity. I'm never worried about disclosures if they're reasonable. I think that's an appropriate way to get at it. But bans on whole categories of speech, and especially if they apply to some people, but not other people based upon their identity, it's a problem.
And Nate, during the elections, with your role in the county attorney's office, the supervisor utilizes you as his resource instead of having outside counsel,
Yes.
correct? So in your role as the supervisor's oversight of election,
And he's the canvassing,
Also the canvassing board.
yeah, so we're.
spend a lot of time together.
Yeah, so I wear, in essence, when I'm doing that, I wear 3 hats, and we have representation agreements with supervisor's office and for the canvassing board. My primary client is the Board of County Commissioners. And it has not happened, but if there were to be a conflict between the supervisor and the Board of County Commissioners, then I would not be representing the supervisor in connection with that matter. So I have my rules governing members of the Florida Bar for my own personal ethical conduct on that. And, thankfully, in the past 4+ years, we've not had any conflict with the supervisor or involving the canvassing board. Everything has worked out very well. And all again, that's how that has worked for our office.
And we were talking about the special act, the Broward County Special Act
Sure.
governing elections. So if you could share what you were educating me on about primary elections versus general when municipalities, and it was at the request of working from the financial side of what was most cost efficient and equate to the best turnout of elections is when the city started rolling over to the November elections.
Right, so back in 1975 is when the special act was first passed that allowed for, that really designated municipal elections for Broward County, that they would be handled by the supervisor of elections office, and they would be canvassed by the Broward County Canvassing Board. This is very different than even some of our neighboring counties, like in Palm Beach County, many of their municipal elections are canvassed at the municipal level. I don't know how they use the machines. I don't know where they get them from. I don't know whether or not there are people literally checking boxes on a piece of paper in some of these small towns. And if you look at a lot of the case law that's come out of Palm Beach County involving election disputes, they're all at the municipal level, where it's the canvassing board of the town of Palm Beach. In Broward County, it's developed over time. We used to have so many of our elections, in Fort Lauderdale had its elections until relatively recently in March. It was the March municipal elections, and most cities had them in March. Over time, mostly in the early 2000s, it began to shift from March municipal elections to November elections. And there were a number of changes in the special act in 2003, 2004, and 2005 that provided for example, if you were going to have your elections in November during years of general elections, no primaries for municipal elections, for example. There are still permitted primaries in a very rare circumstance when you have a March municipal election. But the general thinking, my understanding is that cities were moving to November for 2 reasons. One of them is the financial, because under the state act, the municipalities are wholly responsible for all costs associated with their municipal elections. So if you have a standalone election, in fact, it used to be in February, I think, for a while, early on. If you have a standalone election, well, the supervisor is providing you with polling equipment, polling staff, a location that is only being used for your election. So you're paying 100% of the costs associated with that. When you're having it in November, we're able to provide, in essence, a flat fee for that service for the additional expense associated with the municipal elections. Like, for example, in 2020, two particular cities in Broward County, Coconut Creek and the town of Davie, decided that they wanted to have like 18 ballot questions on a presidential ballot that was already very long. Well, even though it was in November, they wound up paying more because we actually had to print out an additional sheet for their elections. But if we're not printing out additional sheets, there's a set fee that's far below the actual cost associated. The cities also wind up getting the benefit of early voting when you're using a November general election. So all of those go into early voting. You wind up also having the extended period of time for your overseas voters to be able to return their ballots to the supervisor of elections office and have them counted. So the cost associated with the November election generally seems to be less. The turnout obviously is significantly higher, as we all saw from the March municipal elections that have, as a general rule, to say it's anemic would be an overstatement. I think we had 4% turnout in some locations. And you obviously have a far higher turnout for your voters in November.
Question on that.
Sure.
What's your-
Some cities that have gone to November for municipal elections, are some of them doing the primary?
No, they're not
August?
permitted.
They're not permitted.
It is specifically prohibited by statute that there are no primaries for municipal elections that have elections. Gotcha. Period, full stop, period. Okay. Yeah, the language is municipalities that have general elections in November, even numbered calendar years shall not have primaries for such elections.
And that word shall, is a lot, the public doesn't realize sometimes the difference between shall and may.
Yes.
And with shall, there was no discussion on it. So.
Thank you.
But if you could give us a great overview of your role as Inspector General, and
Yes.
I see more with municipal than I do even local, so it'd be great.
Yes, thank you very much for the opportunity to participate in this meeting and she very much to welcome that you give me chair. I'm here with my colleagues, interim general counsel Catherine McIntyre and senior assistant legal counsel Jenna Gargano. I'm very pleased to tell you that I am appearing before you today as the Inspector General for Broward County and its municipalities as of Tuesday. Until Monday, I was the OIG General Counsel. And, you know, just to give you a little bit about where I'm coming from, I've been with the OIG for about 10 years. And I really developed or crafted the ethics enforcement program and now I was supervising it. And I also have taught graduate students in the field of public administration on the subject of ethics and public service ethics, I should say, and professionalism. The areas that I wanted to go into with you start with my office's function. We get our power and authority from the Broward County Charter at section 10.01. And it says that we are created to investigate and report. And we also refer to the charter on instances of misconduct and gross mismanagement by the officials, providers, and employees of the charter government of Broward County, which would not include the constitutionals, and of the municipalities within Broward County. And misconduct is defined in the charter as a violation of law, you know, statute, code, charter, constitution. And it also includes acts of fraud and corruption and abuse, right? And then you have this gross mismanagement charge as well. And so when it comes to the subject of ethics, it really is a very small subset of the investigations that we conduct on misconduct and gross mismanagement. So, you know, sometimes when I read in the paper, you know, that the Inspector General is the ethics star of the county, I have to laugh because, you know, he or she is really the, if you want to call it a czar, much more than about ethics. My view on these ethics laws is, and it's really more from my academic side, is that they're designed for the purpose of identifying where a person may have, a public official or employee, let's be specific, a public official or employee has a conflict or a clash between their personal obligations, the obligations in their personal life, what they're doing for themselves and for the family and for people who are close to them, their business, and so forth, and how that might interfere or clash with their duties to the public as a public official or employee. And so the ethics laws, in my view, are designed to either quash that conflict, to manage that conflict in some way, or to expose that, right? And often we find that it's of no fault of the official or the employee that they find themselves in this position of having this conflict of interest. I think that's important also to understand, especially when we're talking about the enforcement of ethics and the fairness of enforcing it to the letter in every case. So, our office is also empowered by the charter to prosecute, and I use little p, violations of the ethics code, the county ethics code for elected officials. We're empowered by the charter to go before an administrative hearing officer and file a lawsuit against an elected official of the county, whether it's the county or a municipality, alleging that some aspect of the code has been violated. And we use the Florida Rules of Evidence, we use the Civil Rules of Procedure, Florida Civil Rules of Procedure. And ultimately, the punishment could be, if the violation is found, I think there must be a fine of between $250 and $5,000 per incident. And then, it could be, there could be also a public reprimand or censure or a fine. No, I'm sorry, other than the fine, disgorgement or restitution of any personal financial gain that might have occurred as a result of that violation. And so that's more or less my office's involvement in ethics and in enforcing ethics. So Fort Lauderdale officials and employees are subject to, as Drew has indicated, many sets of ethics laws. We have the state constitution. We have this comprehensive state ethics code for for public officials and employees. And to answer your question, Mr. Brandon Williams, with regards to its general subject matters, so the state ethics code has standards of conduct and disclosure requirements for gifts and other things of value, misuse of public position, conflicting contractual or employment relationships, voting conflicts, the employment of relatives, financial disclosures, lobbying after leaving public service, and ethics training. And those allegations are handled by the State Commission on Ethics out of Tallahassee. They have their own process, and we very often will find at the conclusion of an investigation probable cause, not for a local code violation, but for a state code violation. And we will refer those matters up to Tallahassee, and they will take it from there. So, in addition to the state code of ethics and the Constitution, there's of course the detailed code of ethics for elected officials, the city charter, and the city code. Right? So I did do a quick online survey of, or sample, I guess, of to see how other city charters address the subject of ethics. And I found 5 examples that I wanted to talk to you about. Because I think they're pretty representative, right? Deerfield Beach at section 8.01 says that all city officials and employees are subject to the standards of conduct set by general law, the city charter, and any ethics ordinance the city may publish. And this is, I think, in the realm of redundancy that Mr. Myers was talking about earlier. Sunrise at section 701 says the same, but also added that its city commission shall pass an ethics code for elected and appointed officers and employees within 90 days of that charter amendment. It mandated enactment of the ethics code by a majority vote and any amendment by a supermajority. Coconut Creek at section 901 says that the state code of ethics applies to the city, provides that any officer or employee who willfully conceals a financial interest in a city transaction or willfully violates the state ethics code is guilty of malfeasance and shall forfeit their office or position. Allendale Beach at section 701 is like Deerfield Beach, saying that officials and employees are subject to general law, the charter, and that the commission may establish a code of ethics. But it also requires city officials and employees to disclose personal financial interests in a contract, zoning, or sale of land, goods, or services to or from the city. And it also prohibits officials or employees with such a conflict from participating in that action or transaction or vote. Comparable to Coconut Creek, violators would be guilty of malfeasance and subject to removal. Or it actually says, and shall forfeit their office or position. How that actually happens, we don't know, because I don't think we've seen it. And contracts or sales would be voidable if made in violation of that charter section. And finally, in North Lauderdale at section 9.4, they have a very similar requirement to disclose personal financial interests and prohibitions against officials and employees engaging in transactions or votes where they have such interests, and also has that redundancy in it that we've been talking about, and even goes as far as saying you cannot relax the general law implementing any code. I have a set of PowerPoint slides with links to the laws that I just talked about here. And, you know, if you would like, if I have to provide it to you on request. And with that, you know, you're available for any questions that you might have to help you with your mission.
Thank you. And I think it's very important because the public had no idea. And this is the opportunity, and this is a great forum for it to be discussed and brought forward, so people are more engaged in understanding how government operates and what is expected of the elected officials that serve them. And I know when we do judicial races, the consultant is required, along with the candidate, to attend the ethics training on campaigns. And they will lay out examples to us of bad decisions in judicial races. And it's a good training. I think it's very worthwhile. I think this is the first step. We've never done this before for the public to have this opportunity. Elected officials go for their training. It's all, you know, hush hush kind of stuff. The public has no idea. And I think that this is really important to bring forward to make, you know, let it be known. And then we can discuss this as we move forward as to where things are going. I'm waiting for tomorrow to end in Tallahassee because we're not sure how everything that we're really discussing even gets affected until the outcome of session. It's an interesting time. I can't thank you, the four of you. enough for coming out and coming up here to uptown. Doing this.
But before we wrap, I did have a question. I don't know if it's for Gio or Trudy. You mentioned earlier that when charter provisions from the municipal level are in conflict, especially on ethics, with the county shall prevail. Of the 5 cities that have taken the initiative to put ethics language into the charter, really does seem like 3 of these are redundant statements based on what already exists.
I don't want to say that these are the only 5. These are not the only 5 that have provisions, ethics provisions in their charters, certainly.
Got it.
Most definitely. I thought they were just kind of representative kinds of things that, that the cities have done.
But have there been any cases where litigation has removed charter language for being in conflict?
So I think the language talks about conflicting ordinances. It doesn't, I don't believe it uses the word charter. The only reason I seem to be recalling that is we almost had litigation. Shortly, I forgot what city it was, but it was shortly after.
I think it was Wilton Manors.
It might have been Wilton Manors. I remember the lawyers involved. I won't say they're fantastic lawyers, not your firm. Your firm, fantastic
That's
lawyers
why I'm
also,
telling you, it's Wilton Manors.
but really, really good lawyers. And we were directed, I was really happy because I used to love to litigate back then. But we were directed in a 5-4 vote to sue them. And their position was, no, they were putting something in their charter. But in order to put something in the charter, I think there was some process. What's that? You can't reach you, so he's looking for me. I put something in the charter required, I believe, an ordinance. So we prepared the complaint. I was really excited about it. And then there was a motion to reconsider the next week. It was a 5-4 vote to sue, and then it went 5-4 the other way. So it's never been tested. I believe that there can't be a charter provision, in my view, inconsistent with our ethics ordinance. But I will tell you that there are people who take a contrary view.
And to round it out, we have a final presentation that we put on here from the city attorney's office.
That'd be great. Great. Thank you. If you'll indulge me, let me just tell you a little about myself for those of you who don't know me. My name is Paul Van Gel. First of all, I've been with the City of Fort Lauderdale as an attorney for almost 20 years. I've been an attorney for almost 39. I've worked exclusively in Florida local government for close to 35 years. I've been a county attorney. I've been an assistant county attorney. I've been a prosecutor, and I've been a legal services attorney. I'm board certified by the Florida Bar at City, County, and Local Government since 1997. Now I will begin with some history, which may or may not interest you. And I'll go chronologically. So in 2000, the city's lobbying ordinance, and I'll come back to this because I'm going chronologically, was adopted in the year 2000. In 2007, there was a resolution 07-46. And in that resolution, the city commission set a policy whereby no member, and I'll quote here, no member of the city commission shall utilize any city stationery, city staff, or other city resources in connection with soliciting donations. No member of the city commission shall utilize the city's name, the city's logo, their elected position, office, or official title in any advertisement or solicitation for donations. And that no member of the city commission shall use City Hall. That has a meaning, I guess, right? Or any other city. On one of the displays. Shall use. Right, Mayor. Shall use City Hall or any other city-owned property as a place for soliciting or accepting donations. Also in that same year, 2007, there was an ordinance 07-110 by which the city commission created Article 10 of Chapter 2 of the Code of Ordinances, and it was titled Solicitation of Donations. The ordinance provided, and I say that on purpose, provided that no member of the city commission shall knowingly solicit or accept any donation or any third party from any person or entity that is doing business with the city. It also provided that no member of the city commission shall utilize any city resources in connection with soliciting donations, and that no member of the city commission shall utilize the city's name, city's logo, such members' elected position or official title in any advertisement or solicitation for donations. It provided for the appointment of a special master who would hold a hearing to determine whether a violation had occurred. The special master could impose a $100 fine for the first violation, a $500 fine for the second violation, and $1,000 for any violation thereafter. The county code of ethics for elected officials, which we've spoken about this evening, which was first called the Code of Ethics for the Broward County Board of County Commissioners. It was adopted in 2010, which I think we heard, and was extended to include elected municipal officials effective January 2nd, 2012. Meanwhile, effective in January of 2012, the City Commission of Fort Lauderdale adopted Ordinance 1142, which harmonized the city's lobbying rules with the counties. And also effective that same day, the City Commission adopted Ordinance 1143, which repealed Article 10, the solicitation donation section, in its entirety because, and I'll quote, certain portions of the Code of Ethics, and it's talking about the county Code of Ethics, conflict with current portions of the City of Fort Lauderdale Code of Ordinances regarding solicitation of donations, and to eliminate confusion and avoid duplication, certain portions of the City of Fort Lauderdale Code of Ordinances are being deleted. So the city recognized the preemption, of course. What's left of the city's lobbying ordinance, which complements the county ordinance, is registration and lobbying by former city commissioners, board members, and employees, which prohibits lobbying activities for a period of 1 year after termination of employment with the city or within 1 year from the last day of service to the city in any official capacity. Purchasing. Section 2-188 of the Code of Ordinances is, and that's in the procurement part of the code, and it has 3 components. So this, of course, is applicable to employees. So in accordance with Florida Statute 112.313, which we've also discussed this evening, neither the chief procurement officer nor any member of their staff nor any other employee of the city engaged in the request for or actual procurement of goods and or services shall have a financial interest or have any personal beneficial interest, directly or indirectly, in any purchase or contract of any supplies, materials, equipment, services used by or furnished by to the city. Such conflict of interest may include, but may not be limited to, an individual ownership in whole or in part of firm seeking to contract with the city. The chief procurement officer, every member of his or her staff, and any other employee of the city engaged in requisition of procurement or procurement of goods and services, prohibited from accepting or receiving from any person, firm, or corporation to which any purchase or contract may be awarded any money, rebate, gift cards, anything of value, or any promise, obligation, contract, or future reward or compensation. There's another section, another subsection that says that financial disclosure shall be submitted on an annual basis. That's in compliance with state law. I included in the materials that went with the agenda also section 2-183, suspension and debarment, and that applies to vendors, of course. So I'm going to go overview of the different kinds of ethics rules and ordinances. And then what we also have is an anti-nepotism section, which is 2-43. An appointing authority may not appoint, employ, promote, or advance, or advocate for appointment, employment, promotion, advancement to a position, et cetera, et cetera, et cetera. in which such appointing authority is serving or over which such appointing authority exercises jurisdiction. From any individual who is a relative of the appointing authority, and of course, there's the definition of the relative and the consanguinity. No person who is related to an incumbent city employee or official within the degree of the relationship set forth in the ordinance shall be hired for employment in the same department in which such incumbent employee is employed or holds an appointed position. We also have a policy and standards manual, the PSM. And there's a section regarding there's a code of, there's a standard, a code of ethical standards for employees. And I have that also. So that's, those are rules promulgated by the city manager that apply to city staff. So that's about it.
The things that were under purchasing and procurement, was that just a restatement of what's in Florida statute 112.313? Or is this a clarification specific to Fort Lauderdale?
I believe it's a restatement, it's a little reworded to apply, to be in our code, but it actually says in accordance with FS section 112.313. So it tracks it.
Got it.
And the financial disclosure for FS 112.3144. So yeah, it tracks the statute.
And Paul, can you repeat the section on charitable? And I would believe that people would be required to file the form that the county's prepared, even at the city level, for solicitation of charitable contributions or use of the city or.
That would be 119 because it's superseded by the county rule. Or are you referring to what?
Right,
we used
what
to
you
have?
just read, yeah. So that came out and we
Came
go
out and-
under the county. And if you're doing that type of solicitation, then you would have to file the county form, the solicitation.
The county rules would apply.
Right, I believe that city commission was.
Field.
Right.
Right.
In favor of county preemption.
And then under the county, you do the solicitation and file the form. So that's public transparency.
Right. Of course, the county attorney could speak.
Yeah, no, I think that's correct. I know that a couple of years ago, we also changed our definitions a little bit. That there were some solicitations on social media. I think we exempted. I don't remember all of the
I
specifics.
think GoFundMe and that kind of stuff is.
Yeah.
Correct, as long as you're not targeting specific individuals to make a donation, it's exempted.
Yeah, isn't it?
It's not a little hairy, actually, because, it really speaks to you're doing charitable contribution, solicitation in your private capacity or your official capacity.
Yeah.
It's just really two different sets of rules.
You're bringing back that nightmare of going through that now. Yes, you refresh my recollection.
Sorry, Richard, you were on the county charter board going through this.
When we enact.
You were, no worries. So you must have been sitting there. I had a.
Are you gonna blame me for this?
No, I was very direct as to the problems I thought that existed. And my office was accused of a lot of different things. It was a very interesting time.
There was a real concern at the time we passed the first 2010 that the county commission was doing nothing.
Right.
And so the charter review board said, we're gonna make the county commission do something.
Mhm.
And so that's when we set up that procedure and so that's because otherwise, because the county commission had been talking about this for years and doing nothing.
And you know something, Richard, I'm conflating two things. So no problem with the charter review folks, because I think reasonable people can say that there wasn't significant progress on that front. It was with the actual ethics commission in 2010 that it got heated.
And what happened was you had a couple of city members, and it's Paul Schechter specifically, that had been on it about putting this ethics code on the county commission. And the county commission said, city people are going to tell us and not them. And that's when they got together with League of Cities and said, what's good for the goose is good for the gander.
Very easy charter amendment to draft,
Yeah.
to extend it.
I'm sorry, but
Yes.
there's a list of 5 items that do not constitute either official charitable solicitation or private charitable solicitation, so you have to look at the whole thing globally.
And which ones?
Under the county,
Under
under the county ordinance, yeah. So postings on social media pages, email correspondence directed at groups of 50 or more, GoFundMe or similar online campaigns, newsletters, referencing a charitable cause, provided that no specific identifiable individual or target. I don't need to read those.
So just for,
I'm sorry.
so just for the record, and mostly again for the public, I have the answer to this, but I'm gonna ask the question regardless. If we needed to take something out of the county's charter because it was preempted to the state, what is the process?
Removing a provision in the charter. So we recently made some changes. There were changes to licensing and basically preemption. So we had a very rigorous was central examine,
The central
the
exam.
central examining boards. I think we had 9 of them. State law changed. We didn't need them. We wanted to change it. We amended the charter. It has to go to a vote of the electorate. And actually last week, I guess Tuesday, we amended our ordinance and have to be consistent with the revised charter provision. But the charter is amended by the voters. Charter amendments can be proposed by the county commission. They can be proposed by a charter review, or it can be an initiative, I believe.
Can I just add one thing to that? So Broward County, being a charter county, also has more home rule power than non-charter counties vis-a-vis state law. And that's really tricky to get into, what kinds of things the charter county can do as opposed to a non-charter county. My experience before I came here was with non-charter counties, and it's different. It's different, and the home rule rules are, with respect to state law, are different.
And just to kind of belabor my point, but just so that it's on the record. How many times roughly in the last 3 years have we had to amend our ethics ordinance because of changes in state legislation?
It's interesting, Harrison, because I will tell you, to the credit of the County Ethics Commission back in 2010, we were very cutting edge. We were ahead of anybody with this stuff, even training. I think training was added to the statutes way after it was in our code. We used to require 8 hours. We cut it back to 4, and I think the state adopted 4. So I've had to change it to amend the charter because of changes in state law. Our ordinances had to amend them. I mean, this last one was strategic. I don't know that we've really had to amend them. What I was worried about was we'd get a ruling in the state case under the state lobbying provisions. I think ours suffer from some of the same issues, I mean, and then we'd be in no person's land. I mean, do we repeal them automatically? What do we do? Plus we had to comply with the state rules anyway, and to engage in training that covers these inconsistent provisions just seemed like it was going to lead trouble. So we thought it was a good idea to amend it for litigation risk reasons and just to be fair to elected officials and have one consistent standard. But I don't think we had to. And I'm trying to think, because ours have always been more stringent, I believe, than the state code. I'm not sure that we had to amend it to.
Right, and because the state laws expressly allow us for more stringent standards.
Right. So, and again, to bring this in for a landing, unintended.
What a great line here, right?
I know. The reason that we wanted both yourself and the Inspector General to come is we wanted to get a sense of what the baseline is in terms of ethics for the city of Fort Lauderdale, absent a single word being mentioned about it in the charter. We have the option as the Charter Review Board to suggest things to first the board and then the people to add to this charter for the city that would be more strict, provided they don't conflict with state or county ordinance. So we are really in a very narrow bandwidth of what could be important enough that we absolutely want to see something in charter language that we don't anticipate is either going to be preempted in the near future or not something that we are willing to deal with the dynamic nature of how this has been changing year after year on pretty much a living basis. So I just, again, to put it out there, even if this board does not necessarily make recommendations to put language in the charter, it is not because we think that there is an absence of ethics baseline requirements for elected officials and city staff.
And Harrison and Jody mentioned this before, and I sort of glossed over it. Yeah, on the elected officials front, you know, the landscape's pretty well covered. And there are obstacles to the city being able to do certain things, I think, because of the two potential conflicts, state law and the county charter. But because we have not extended, and I don't believe plan to extend, but maybe they'll tell me I'm wrong, our employees code to the city, you know, that's, you know, fertile ground for you to consider. That doesn't necessarily mean it has to be in the charter. You know, most of our ethics code is not in the charter.
And there is one area in the county charter that may have to be extended because they're going to have a new constitutional officer. And Drew and I had that conversation. It was not foreseen at the time. And then the Constitutional Revision Committee on the state level created in all the counties newly elected constitutional officers, which is omitted currently. Broward is the tax collector, Miami-Dade is the sheriff. So
And the
those are
supervisor.
other areas that the county
And the supervisor of elections in Miami.
and the
County as well.
supervisors
That's currently
always
it.
omitted.
And we've had, and Jody, I think you didn't list the constitutionals as within your jurisdiction.
That's right.
So
Yeah,
yeah.
it's just with regards to the county, the jurisdiction of the county officials, employees and providers, it's limited to the charter government of Broward County.
So we have a provision, and as Judy was mentioning, and I initially thought we would have said, you know, just the independent constitutional officers under Article 8, Section 1D. But we didn't. We actually listed the 4 constitutional officers we have, and not the 5th. And the state, of course, amended the Constitution, and you know, and I take no position on this, but you know, the county liked operating the way it operated, and now we have to have a tax collector, which is causing a lot of issues. And we also had to enter into contractual arrangements with the clerk because there were some shifting of responsibilities that were previously permissible that are no longer permitted. And by the way, as far as I know, the arrangements we had were working extremely well. So hopefully the new arrangements that the state has mandated will work as well.
And a lot of this, again, when the public votes on something at the county charter and all that, they don't necessarily understand the impact on cities. Or they vote for something at the county thinking it automatically impacts the cities, and it doesn't. So, you know, all these type of communications and educational forums, I think is so key. Because I chuckle when some people, you know, individuals will say something to me. I said, well, you voted on it at the county. I mean, what were you thinking? But they're just not educated enough to understand the influence of the relationships of each form of government that we have. So this is really well. Yes, Paul.
Madam Chair, there are 3 sections in the charter that I didn't mention, but I included in the materials. So they're not directly along the lines of what we've been discussing, but they're related. So there's 3.07, which is not to direct appointment of employees. So neither the city commission nor any of its members shall direct the appointment of any person to office or employment by the city manager or in any manner prevent the city manager from giving their own judgment. I'll spare you reading the rest of it. Then there's 2.08, absence from 4 consecutive regular meetings. And in that same paragraph, any member of the city commission who shall while in office be convicted of a felony, if it's more serious, shall thereupon forfeit. Forfeit his or her office, and then 7.15 applies to candidates, conduct of candidates.
I have a question on that one. I think for maybe vendors is a misdemeanor, not a felony. Know that? In terms of implication for continuing to do business with the city. That makes sense.
Oh,
Standard.
that's about the
I think it's
debarment,
does that sound right?
the debarment section,
Yeah, vendor suspended, I think, with a misdemeanor. And I was just wondering, do any other cities mimic that? Yeah,
What section?
3.08.
Thank you.
regarding.
So the vendor piece is, I don't think it's in 3.08.
So the vendor piece is in 2.183 of the code.
Yeah.
So that's it, that you should have it. Yeah, it's in the back. Yeah, probably. That's 183 code.
So Michael, I don't know what your timing is for the, are we okay to keep going? Okay, I just wanted. The public input is next.
Yeah.
Item.
It's 2.266 penalty for 2.65. That, here, 2.18 for
183 suspension and debarment. It's long.
Yeah. In other words, it's a lower standard, right? And so just it's interesting. I mean, my question is basically, any other municipalities contemplate an equal standard for vendors and organizations?
It's actually bifurcated though. There's a possibility of suspension and there's a possibility of debarment. Permanent debarment.
I think the code provisions are all of them.
Yeah, they're all over. Yeah.
At one time, there was discussion as to whether or not that should be extended where we incorporate county and cities to make us aware of if a vendor's being disbarred in one form of government, if it should automatically roll over to the other form of government.
Yeah,
It's
it's a good idea, and when we end up litigating a lot, with vendors, and sometimes they take positions that we're asserting false claims, counts against them, and we do let them know that they could wind up on our debarment list, and that I think they have to disclose that generally on solicitations in other jurisdictions if you've been debarred by anyone, but maybe not everywhere, and that's very interesting to
Right.
require it.
In our code, a charge of embezzlement, theft, forgery, bribery, falsification, etc., could result in suspension, whereas conviction by or judgment obtained in a court of competent jurisdiction for those offenses in connection with the vendor's commercial enterprise, that could result in debarment, permanent debarment.
just one last question, Paul. Drew shared the process just so public's really well aware of changing the county charter. Walk us through again, just briefly, changing the city charter. What's that
Same
process?
thing. Different. So,
Well, I'm not sure how to. Okay, so what we've done before and the way it works with the city is that the city commission would pass an ordinance containing the charter amendment the ballot question, I should say, containing the ballot question. And then passage of that ordinance is conditioned on passage, approval by the elected.
And ordinance would always also contain the exact language that's going to be added to the charter. And also call a special election.
And
They usually do, yes, or,
do it by
and they also do a
resolution.
resolution.
So there's an ordinance and a resolution.
Resolution setting the election.
which again, it's important to realize that changes in the charter are based on voter performance. They're the ones who vote. We are not, anyone sitting around this table, we are not the final terminator of what goes in the charter. We are an advisory board, make recommendations, then it's up to the county, the city commission, whether or not to adopt our recommendations and move it forward to the voters.
And then
So-
let's not forget about the 75 word rule.
Well, and that goes through.
And I heard the term special election thrown around. Please don't.
And the cost of that.
Yes.
Yes. And at this point, anyone here that would like to say anything about it? Come on up. Come on up, son. Yes.
My name is Donna Mergenhagen. I'm a resident of the city of Fort Lauderdale.
Near
And-
uptown. Near uptown.
Yes, actually, I love this location. I could practically walk. I shared with some former colleagues of mine last weekend that I might attend this meeting. And I want to tell you what they had to say. We were all colleagues in the medical device industry for various terms of service. And when we left, for one reason or another, a merger and acquisition, a retirement, a semi-retirement, or a dissolution of a position, none of us were able to work within a competing industry for a minimum of 5 years. For many of us, it's very hard to understand how elected officials can be lobbyists. And for us, that represents basically a competitive situation. Now, in private industry, there are non-compete agreements that we have to honor. And so I respectfully disagree with you that whether it's half a state away or half a county away, the public's perception for the most part is that people who are elected officials and are lobbying simultaneously 6 months later, 1 year later, are perhaps operating in a way that we can't respect best based on our previous professional experiences. So the issue of lobbying as when elected, after elected, I think is a very sensitive hot button for many members of the public. And I would just like you to keep that in your mental files.
Could you
Thank
explain why it's a hot button? Why, we could just go into some detail as to why.
Good for
I
the
know
goose,
lobbyist is like a dirty
good for the
word,
goose, good for the gander.
meaning.
Meaning, if I had to leave my industry of 35 years because my company was sold to another company, then that made sense to me because I understood the rules going in. But why aren't our elected officials held to the same standards? Because the reality is when you're elected official, you are privy to information, relationships, channels of communication that most of the public is not.
So it's
So-
the idea that they have a foot up. They have sort of a inside information and some.
Possibly, yeah. I mean, networks are networks. Yeah, even if it's not published information, there's a lot of information that is channeled through into an elected official.
Thank you, that was helpful.
And,
Thank you for your time.
and ma'am, I avoid my personal opinions on these things. What I'm giving you is my opinion under the First Amendment. So that maybe is the distinction. I agree with you. There are at a minimum optical issues involved. And these are difficult questions. I mean, there's a case pending right now at the 11th Circuit Court of Appeals. We're not sure how it's going to come out. Really smart jurists are going to decide this, and then it may go up one level still. So who knows? When Citizens United became the law, I guess in 2010, so around the same time, a lot of people said it was an outlier. It isn't an outlier. It was the beginning of a wave of decisions. Now, sometimes the pendulum starts to swing back the other way, and we just have to predict where it lands. One of the things that I'm very happy about with our code that we did change, initially it did apply, as I think I mentioned, to compensated and uncompensated lobbying, which tends to get very murky. So I'm glad that at least it's focused on compensated lobbying, believing that the level of court scrutiny is probably a little bit lower on that basis. So there's more room to balance concerns of the nature that you just mentioned. So that's you make a good point, and I'm not telling you I disagree with you or that I agree with you personally.
No, I understood that you were not expressing a personal opinion. I am expressing my personal opinion and those of many former colleagues. And as a point of interest, there are many states who are currently considering the dissolution of non-compete agreements. So all of that might change. But again, it's an optics. Thank you very much for your time and your volunteer efforts on this board.
Good evening, Bill Brown, president of the Barrier Island Central Beach area. Mr. Graham Williams kind of said what I was going to give some public input. You have a county code of ethics that is the parent umbrella of elected city officials. And now you have the Form 6 on the disclosure side from the state that oversees both the county and local elected officials.
Oh, just for clarity, Form 6 is already used at the county. Form 6 has already been used at the.
Yes, but it's now required.
Yeah, it's city.
Yeah, that's
all.
city
You
now.
can't just add city.
So to go in and change anything and that would be more restrictive, I don't see what that would supersede that's already at the county level. So you said it very well. Thank you. Thank you.
Dean. You gave up Riverwalk tribute to.
I went there too. I have a couple questions to clarify things. So let me give you a couple of examples and you can help me. So as an elected official, we're not allowed to solicit for funds. Can't do it either if we, let's say we are on a host committee for a charity event. Is that not possible or it is possible? It is possible. That's what I thought. Okay. So we can solicit, we can use our name to be part of it for a charity event.
Definitely, you just need to follow, you need to follow.
To close it.
Charter and what within your office, your staff, your computer, your emails, whatever, if you wanna get into that, then, there's a whole regulatory scheme
I
for you.
just wanted to clarify that because Paul talked about just the prohibition for soliciting, but there were exceptions when it comes to for charities, correct?
What he was saying, there used to be more restrictions on it, and you lessened the restrictions once the county passed the code.
Right.
And that's what we were saying, as long as you file the form.
Right. Okay.
Yeah.
Second thing is, now, this case you mentioned at the very beginning, I'm sorry I walked in late, I was at the wrong thing. You talked about the case that's now been adjoined, the enforcement of the statute or ordinance has been adjoined, which my understanding is that it now allows for cross lobbying. And now, like if I want to represent somebody in Oakland Park. According to that introduction, I'm now allowed to represent a party in Oakland Park. Is that correct?
Well, yes, because the county code was conformed to provide the same restrictions as under state law.
Right.
And so once state law was enjoined, we basically suspended our county lobbying prohibitions and instead just put in a disclosure requirement that is being further amended on May 23rd.
Not that I have any of that stuff, but just one, if I'm asked. If I'm asked, exactly. And so the other thing is, you know, sometimes I'm invited to go speak at an event. And there's an admission charge. But I'm asked to speak as mayor, either to welcome people or to speak on the topic. Do I have to pay the admission? Number one. And number two, am I allowed to eat anything that they offer at the event?
Unless it's an honorarium event or honorarium related expense, you should just vet the details with your city attorney. Those things are always difficult and they're very, very fact
I have
specific.
all the talent here at the table.
Yeah.
I need to know the answer.
You-
Because
you're-
I 2 or 3 times a week, I'm asked to appear as mayor, welcoming, but sometimes it's a ticketed event.
You always say submit in writing and get written response.
Yeah, I think it depends, there on who is who is inviting you, who's hosting the event, and then who's paying for the goodies that come along with the event.
So let's say it's like a couple weeks ago, there was a group of travel agents that came to the county. They were having an event at the convention center, right? And they said, we'd like the mayor of Fort Lauderdale to come.
Are they looking for anything from the city of Fort Lauderdale?
So that's the key, right? If there's no business connection with the city of Fort
Well,
Lauderdale.
that's part of it, yes. And yes, I think that is your, you know, the fair compensation for giving
That's
speech.
Now-
that's the consideration, I thought.
But if it's gonna be valued at more than $50, you may have to.
I would have a problem.
Maintenance.
If the ticket was $100 or $500, sometimes these conventions, the fee to attend is like a lot of money.
Right, so the fee may not matter. I'm gonna defer to Kristen on this one, because she seems to remember all the little.
They're very fact specific, so I'm hesitant
Yeah.
to provide any advice. What you would want to, disclose to your council and seek an opinion. Clearly, there's a difference between you're going to some conference of accountants, say, and you're giving a speech, you're not eating or drinking anything, and you're leaving.
Right.
That's going to be different than you're going to the Super Bowl for free and you're giving a speech, to 3 people that you're sitting next to in the stands. Do you see what I'm saying? How the facts of a situation matter?
But
I'm not going to the F1.
Right.
So.
Mayor, the primary distinction is going to be, who the donor
Yeah.
is. That's going to be your primary consideration. So if it's not, as Jody mentioned, if it's not someone that's looking for something from you, they're not a registered lobbyist or vendor or principal of a lobbyist, then you're going to have a lot of discretion, very, few limitations, maybe. But if it's in your official capacity, which it sounds like it may be here, you may be limited to the $50 amount that Jody mentioned.
It
So
might be an honorarium event.
it might be an honorarium. So there are so many moving pieces.
It's like the tax code. It's really complicated.
We spend a lot of time on gift issues, a lot of time, because public officials ought to be able to, this is my personal opinion, not the First Amendment. You're elected and you need to be out in the community. And so the rules shouldn't be such that you really can't do that. You're not accessible to people. But at the same time, sometimes the optics, a piece of a 6-foot sub sandwich as you're standing there and then you pop out is one thing, stone crabs and caviar and champagnes and others. So sometimes these are driven by the optics, including the discretion of folks who might look into this if it were reported. So your safest bet always, if it's an issue under the county code, is to vet it with your counsel, who, if all facts are disclosed, can insulate you. If it's under state law, you have to be really, really, really careful, because we give opinions, and then there's an adjudicatory body, excuse me, that makes a decision on that. And if they disagree with us, and you can call the state, you can get an informal opinion from the lawyers or a formal opinion from the commission.
It's best to get it sent down to you in writing, ask for you in the files.
Yes, ask before you act.
As it has been said, it's so fact specific. One of the things that I do whenever I get one of these questions is I check. I do a search under our lobbyist list and principal, and sometimes I'm surprised, because sometimes there's a name that I wouldn't have expected, or you never know. It has to be checked.
Through going back, like Bertha's retirement party
Mhm.
and the surprise gift to the Delta. And Monica then put after the fact an agenda item on,
Mhm.
right? Accepting that gift. Or travel, when Michael Udine, sorry, I've known him a long time. When Michael went to California, Vegas, wherever, and then there was an agenda item about the travel. We used to do that at the county all the time. Prior to travel, the commission had to vote to approve the travel for events, so that there was always transparency.
Right, so, I mean, but, again, that if, and I don't know what our current rule provides, whether it has to be before or after, but it's just an administrative code
Right.
provision. He was going out there on county business, clearly it was, the
Right,
public could
nobody
pay.
object to it, but-
And Bertha's as well, I mean, that, I don't know that, I certainly didn't know that it was gonna be that nice. When I go, trust me, it'll be not nearly as nice. I'll be buying beers to get people there, when it's my turn,
We used
but.
to do it Dirty Ernie's upstairs.
Yeah, I've gone to one or two of those over the years. But in any event, there's a way of doing it and structuring it. There were entities, I didn't know what the Panthers were gonna do, and they're playing tonight. Are they, I didn't know what they were gonna do. It was a surprise, and so you did the best you could. It was going to a good cause. Nobody was being enriched by it, and so you disclose it, you figure it out, and
It became an agenda item, your transparency. and
That's
everything.
right. That's right. We had
It
it.
was within that time period,
But
Thank you.
Stan.
I think you answered my question.
it depends.
Stan Eichelbaum, and I've been part of a number of organizations around the city, and I've had the good fortune to work in a number of cities as advisor to cities, as advisor to developers. Couldn't be more pro-government, and have had great experiences in the trust of government for many years. In groups here, I'm finding an incredible level of distrust that is high anxiety to getting to real issues, I think. I think you're probably gonna cut it off, where the concern is with Citizens United, which is PAC money. And that's 90% of the conversation when you get down to it, and lobbying interactions. And the limitations, and I'm trying to remember, and I've been sitting here, and unfortunately I caught a cold this week in travels. But it seems like my understanding, and I have talked to past officials about it, was that we had a long period in this city of no acceptance of PAC monies. Then we voted it back in.
No, that's totally incorrect.
That is
Yeah,
totally incorrect.
totally incorrect. And I will tell you, because my God is Mark Perry in Tallahassee. And he is the guru of, in my words, the guru of election and ethics law. We always, because there's nothing that prohibits it. And there was never anything here at the city that prohibited. People just didn't think about it.
Just
And
what?
just didn't think about it.
Yeah.
And Harry Stewart was the city attorney at the time. And it was actually a public safety group that put together a PAC. They registered here at the city because it was being used specifically. And Harry's like, we don't do that. And Mark Heron produced all the documents and showed, yes, we do. And that's where the law permitted. So it's never that it was prohibited. It just wasn't thought about being used before. And that was back around 2009.
Appreciated history. So is there any way to limit the PAC influence?
Well, we just undid, that was probably by ordinance. We just changed the limitations of the campaign contributions. Back to Tim Smith and Jim Norville, it was $250, personal only. At that time, the maximum was 500. And we had these discussions in the Charter Review Board meetings through 2017, that if you switch to November elections, it's much more expensive for a candidate to run to be competitive. And meanwhile, in Tallahassee, they changed the limitations from 500 to 1,000. And at the state level, there is no restriction on corporate or personal. So we recommended, and then the city commission adopted by ordinance, to just adopt what the state did. And we just came into compliance with state law.
But that's for campaign contributions.
Campaign
PAC
contributions.
contributions are different. Right. There's no limitation on that.
Right.
That's where you're going.
That's where I'm going. And is there any way to limit the PAC portion of it?
Well, this is Citizens United, doesn't that control? That's a Supreme Court rule saying you can't.
That's where I'm at.
If it's a separate entity, not associated with a campaign, it's a separate entity that collects money and spends money, not associated with the campaign, there's no limitation.
And there's no way to
That's
limit it because of the Supreme Court.
That's a Supreme Court.
So for us, but for not. Okay, appreciate it.
Put stuff on there, and that's, Harry's calling us, you can't do this. And was registered and went through the process, and Mark Heron said, Harry, we worked together at Ackerman. Here's the opinions, and did it, and that's when, so it's never prohibited, it was just, wasn't used before.
Appreciate it.
Nate, if I could just go back to you just to, as we were talking about charter changes for the city. City commission approves a ballot question, goes to an election, and some folks have said special election, and you kind of roll your eyes or give us a little bit more about that.
In terms of special elections?
Yeah, what's your
Well,
give us the pros and
I have
cons.
no preference either way.
Right. Yeah.
His family, on the other hand, has a preference for me.
That's right. That's right.
They do.
Yeah.
I have a problem on election night that I typically will stay until the last ballot is counted. So there have been a lot of 2 a.m. mornings in terms of that. That would not be the case if it was just a city doing a special election for one ballot question. The expense related issues, and also because the supervisor of elections office, other than during large elections, as we gear up for the presidential preference primary or an August primary election or the November general election, supervisor's office swells from about 75 employees to thousands of staff members. So during regular course of the year, there's a very small number of folks that work at the supervisor of elections office, and they are extraordinarily busy with things from registrations to doing list maintenance to make sure that our voter rolls are accurate. When a city suddenly calls and says, hi, we would like to have a special election, you can, if you listen out the window, you can hear the groan from downtown Fort Lauderdale or out in Lauderdale, because there's no ability to quickly gear up for especially a city like Fort Lauderdale, which is going to have a large number of precincts, to quickly gear up for a special election at snap of a finger is difficult. It's extraordinarily expensive, and it potentially disrupts the things that are required by statute for the supervisor's office to be doing on either a biannual or an annual basis. Like right now, in 2023, we're in the middle of list maintenance, which is with a county with 1.3 million voters, is a very laborious process that everybody is sort of all hands on deck to make sure that happens. If a city suddenly said, we would like to have a charter amendment, or for example, earlier this year, we were dealing with a city who had an elected official resign And timed their resignation in such a way that it potentially made it extraordinarily difficult to make the March elections. To which the supervisor's office basically said, if you cannot make the March elections, you will wait until the next time we're having an election, because we don't have the ability to host a special election for you. And then you wind up with the problem of, you have city charters that say that a special election upon resignation or vacancy must take place no less than 45 and no more than 90 days. Well, that's wonderful. You have the right to host your own election. I'll give you the phone number of ES&S. Feel free to buy a couple of election machines and make sure they're certified and get the people to program them. That's why I groan when we hear special election, because it becomes extraordinarily difficult for an office. So
We did have here at the city at one time where Cynthia was trying to argue with us because the state law changed and said overseas ballots have to be 45 days in advance versus domestic 30 days. And it did not work out with compliance of our primary and general election day. So we had to do by ordinance a special change. First was Harry, and it was actually your election with Charlotte that time. And we had to change the registration and the election date so we could meet the county's requirement. It was the state law requirement, now the county's state law requirements. And that started us thinking, it doesn't work anymore. We can't do February to March. Now it has to be rolled back to January. The problem with January is you're giving us 2 weeks to vote because basically it's Christmas and New Year's and Thanksgiving, Christmas and New Year's taking away. So it really became so impractical to have that whole process in place.
So I would encourage, if you are considering making any changes to your, your charter or ordinances in Fort Lauderdale as it relates to municipal elections, to just be very cognizant of the strictures that are within both the special act as well as the Florida Election Code, because the Florida Election Code has a preemption in there as well, that municipal elections, with very limited exceptions, must comply with the entirety of the Florida Election Code. And so there's a lot of different dynamics, and we have cities that have charters and charter provisions relating to elections that are sometimes decades and decades old, sometimes previous to the last revision to the Florida Constitution back, it was 68. Florida Constitution, there are some charters that are just ancient. So I'm unfortunately more than slightly familiar with some of the issues related to the Fort Lauderdale charter as it comes to municipal elections based on the last general election that we had. So if you're making changes to that, just please look at the special act to make sure that you're fitting
Before
it in.
David, we had Jeff, and Jeff would call me up and say, oh my God, Cynthia wants us to do this. That's not understanding. We don't run the elections. We don't own the machines.
Right.
We don't own the trained personnel. We contract with the county. So we need to make sure that we take that into consideration on everything we do, because do we want to go out and buy and
Well-
train and create a whole nother department? I don't think so.
And the other part of that is that the special act requires, again, unlike in Palm Beach County, the special act requires that the Broward County Canvassing Board it is the canvasser of all municipal elections in Broward County, which is very different than in a lot of other places as well.
So
And there were time limits too on the clarification of certifying the vote from November elections versus March elections.
Right.
too. That was
Very
the other
good.
question.
And that's one of the things we need to change in our charter,
Yes, well,
because it says that the city.
right,
council
and you,
judge-
right, and you changed it, right, and you changed it by ordinance as far as sitting for midterms versus all, and that has to be all cleared up. But we
So,
would wait until the election was got done in Tallahassee before we start changing things, and then we discover Tallahassee did something else to us.
so if this Fort Lauderdale City Commission would want to make changes to its charter, ideally, you're looking at elections like presidential preference, and I think it's March, right? 2024. So it'd be that, it'd be maybe August of,
Well, the way that the special act reads is that your choices are March or November. You don't get to choose August
okay.
as a general.
And by extension, and maybe this is too broad, but would a charter change during the March presidential preference primary impact the 24 cycle that would already be technically ongoing.
I'm not really following.
Excuse me, the effective date of the.
Oh, the effective
change?
date of a charter amendment?
Right.
I would look to your city attorney in terms of the specifics, in terms of how your effective dates of charter amendments would apply,
But you could, I mean, if you were worried that you were in a cycle and what you were doing was gonna impact it, you could probably, I would imagine, have a deferred effective date.
And then the other part that we always considered is we would take a look and say, well, okay, this presidential primary, is it one party that's coming out? Or the other party that's coming out, and no one in between. So are we, and I went through that with the editorial boards, are we now directing along a partisan view versus the real intent of municipal elections of no person?
Nate, just for completeness, could you just talk about the applicability of the mail ballot election to Fort Lauderdale?
pure mail ballot election. So there's a specific statute that relates to mail ballot elections. It's specifically limited to ballot question type issues. We've had one or two of these over the years with like small special districts that are doing a bond item where you can do a pure mail election. Yes, for kind of a pure mail election. I don't remember the specific statute off the top of my head. You gave me 2 minutes. I can go pull it up for you. There's a whole series of rules specifically relating to mail ballot elections, the limitations that are associated with it in terms of the timing when you have to mail out the ballots. I've never seen one that you, just anecdotally, I would say, I've never seen one where you wind up with any sizable return. Especially when it's, when it's a very small special district, you may get folks because it's, it's 19 people, it's 45 people, but I've not seen any with larger cities that have resulted in any kind of real turnout.
I just want to mention it for completeness because you asked the question, and we have done it in cities where we've done charter changes by mail ballot election. It's permitted, subject to a bunch of rules, but it is something that's permitted. It is something that
And timing of that,
anytime you want.
we're not gonna hear the groans.
Well, again, you're not requiring the supervisor to do anything other than print and mail,
Okay, which is far easier than.
which is far easier than
Machines.
going and finding hundreds of bodies to go take machines to various precincts and trucks and all of the, the accoutrement for that.
Not to be pedantic, but then who does the counting?
We would actually have to call the Broward County Canvassing Board into session. So the groan may be coming from the courthouse with the county judge that has to come and service chair.
I'm not suggesting it, by the way. I'm just,
No,
it's an educational meeting, so I just wanted to.
I'm assuming the cost is elevated compared to November or March.
Well, yes, because again, it's specific to you.
But the mail ballot election is not an expensive.
It's a printing.
Again, I'm not advocating,
Right.
it's just, it's a relative, as opposed to holding your own special election off cycle, it's a lot less expensive.
Got it. Good enough.
And again, that is purely, that cannot be for vacancies or things of that nature in terms of a mail ballot election. It is limited to questions only.
Questions only, charters.
Yeah, there are two subsections, so it may not be conducted by mail ballot for an election in which a candidate is nominated, elected, retained, or recalled, or an election held on the same date as another election, other than a mail ballot election in which the qualified electors of that political subdivision are eligible to cast ballots. And by the way, it is 101.6102.
So you ready to move on?
I am.
Okay, so I put on the agenda a discussion and possible decision as to, after hearing all of this, do we feel like the charter, we're not talking about ethics recommendations to this commission, we're not talking about anything, we're saying, so our task is to sort of review the charter. And the question is, after hearing all of this, do we feel like making changes to the Fort Lauderdale charter in the ethics area is something we want to do? And people may want to think about it, they want to talk about it, or they may be in a position to make a decision now. But I was trying to sort of focus after all of this, sort of focus what we were talking about as to, is this something that should be on our list of possible changes, or we're satisfied that between the state law and the county code and charter. And then whatever provisions are in the city code, you know, so that's why I put that item on the agenda.
And Drew, just refresh my memory. Are you discussing or is already there where some of this ethics code governs over the employees as well?
You're saying is the county discussing to extend it? No, I'm not aware of any discussion, and it would. I mean, you know, I take my direction from the board,
9 people.
of 9 people. However, and it's a relatively new board. I mean, 2010, nobody was there, right? So we're done because of term limits. But back then, you know, the thinking was every city is different with its employees, and there wasn't any compelling county interest, and let's not jump in. I can only imagine that sentiment would carry the day.
It's now sort of telegraphing my own personal information on this. The state, most cities operate under the state law. The provisions of chapter 112 dealing with city employees and all the things that the Inspector General went through, you know, nepotism and gifts, and just all of those things are all covered by state law. So most cities operate under those. They may have some additional provisions, but again, the question is whether we want to put something in the charter saying that about this, but
My personal opinion has always been, if we can stay consistent with the counting, then we're always safe.
and the state.
Yeah,
I agree, Chair, and I think to your point, you made this several times, I think it's a good one, is we've got to do a better job educating.
you know, it's important that
That's
the
piece.
public realize
Yeah,
that there
educate.
is something
Yeah.
out here.
I will say one more thing, but having been a government official in some capacity, all this is very confusing to a normal, just a good government city employee, city of Fort Lauderdale employees trying to do the right thing. And they have to deal with the state law already. They have to deal with whatever's in your own city charter. And putting another set of, or the elected officials, it's even more complicated because they have the county code to deal with. So am I violating the state law? Am I violating federal law? Am I violating the county code? And now to add another layer, it's very hard for good people to comply. A lot of the people are just, most of the cases, I'm sure, are good people trying to do the right thing. And it's just so complicated, and they don't realize, just like as the mayor was talking about, they don't realize that, you know, there's no evil intent here for him to take a sandwich from the whatever, you know, it's, so anyway, I think it's.
No, sure.
Yes,
And as to employees, there's the Administrative Policy and Standards Manual promulgated by the city of Cambridge.
I know at the county, Kevin Kelleher is always, he's great, and we've worked together many years when he was insurance benefits, and whatever, and always says to me, and there's the ICM, why, you know, all these other rules that govern them. But to me, I lived through those meetings weekly. That's back when the county commission met weekly. And when they adopted this, and like I said, I'll never forget, it was Carl Schechter from Pembroke Pines. And they said, well, it's good for the goose, it's good for the gander, and they incorporated the cities. And to me, that was very sufficient. But the public had no idea that we even had that.
And to that point, I have strong feelings that consistency and compliance is definitely paramount here. I would just like to encourage the rest of the board, especially because we will be going out and having meetings in the public with the community, that we don't prematurely close this door before we've given the public adequate opportunity to raise these concerns, even if that doesn't necessitate a change to the charter.
And by the way, the Council of Civic Associations will be posting this. I think, David, will this be on YouTube or?
It's available.
So we can be promoting it.
So on this item, do you want to just sort of leave it and we'll make a decision at some future date as to whether we, following up on what Harrison said, or you want to?
No.
I think we've received a lot of information tonight, but now we should go back and now look at what the Fort Lauderdale ordinances and charter states about this and see if we do have any ideas. So, and I agree that if we are going to go out to the communities, we should keep this as an agenda item so we can get more feedback.
Before you adjourn, I need direction for the next meeting.
Well, I was just going to say that.
Okay.
The last meeting, we had discussed about the April meeting being this focus, and the next meeting being about public lands. And that was, I know, an issue that the public has come to us. Oh, Drew, thank you so much.
We're, okay,
We thank you.
thank you. So just final comment, if we can help in any way and extend it to your fine counsel as well, please let us know. I promise I will not show up next time. You will have the experts. But just let us know if we can help.
Two Fort Lauderdale residents.
Yes.
One park, but two Fort Lauderdale residents sitting at the table.
We're happy that the Victoria Park is nice and dry.
So the public land issue for the agenda, what is it that you would like to be put up with?
So let me ask this question. We did this at the county. We did at the county years ago where we just did public notice so that two members could get together with the legal staff to discuss an item.
Yes. Yeah, so-
That would be in compliance with. So-
I'll defer to Paul.
So if we could do, because I know that Chris has some input and you have the knowledge that if the two of you could work on that together and just do a public notice when you guys want to meet so that we're in compliance with sunshine, that would.
Is that all right with Paul?
I'm sorry.
Paul and I want to meet together to discuss the setting up the agenda for the next meeting. Are you
But
okay
you have
with
to do
that?
is sunshine.
It would have
notice,
to
a public
be,
notice.
it would have to be noticed and you'll need a place. I don't know the practicality of that. It kind of sounds like a subcommittee, which I don't think you do.
Well, I don't think we can't do.
Well,
first of all,
it's-
Just because something is omitted doesn't mean
Well,
it can't be done. So
Any gathering of two or more.
We agree it
members
has to be in the sunshine.
has to be in the
but-
sunshine, has to be noticed, and it has to be in a public place,
problem.
and we don't have very many public places anymore.
I bet that I asked the county commission, they'll give us a conference room.
So is it a practical concern that you have, Paul, or a legal concern?
Well, I'm concerned that it's tantamount to a,
Well, you have offices, wait, the county, the city attorney's office has offices across the
Are you
street.
saying that there's legal
It's
concern because it
tantamount.
sounds like a
it's
subcommittee?
tantamount to a subcommittee.
No, no,
and
no,
the
no, we
commission
did this
has to
all the time.
authorize that.
Well, when Harry was city attorney, we would do this. All we did was a
I don't
public
know.
notice, and we did.
I mean,
So
There's
any
nothing
meeting,
that
any
says-
gathering, yes, has to be noticed. It has to be. Yeah, the notice has to be in a public place.
we're all beyond that. We're talking about whether legally. Paul and I mean, Chris and I meet to discuss the agenda. We're gonna- Subject to all the sunshine. I don't think there's any problem with that.
I don't think anyone can stop you, but I don't think it is advisable, and I don't think that's intended by the ordinance. There's nothing in we have an ordinance setting up this, the charter revision committee.
1983.
And it doesn't provide for any kind of subcommittee.
Do you think you might take this back to the office and sort of issue an opinion about whether we have the ability to have a meeting?
I believe we've issued opinions, but I can check
Maybe
again.
you could take it up and see.
Richard, if this will help, in the minutes for the March 2nd meeting,
Right,
I had put 5 of these sections
perfect.
that I would like to,
Okay,
to discuss.
okay. I want to put on the agenda what they want to check.
Here's a question too, I just want to throw along those lines, is given the volume of work we have, is there any interest in maybe meeting twice a month? As a interest in that, instead of just once a month right now we meet, given all we want to accomplish. So,
That's up to you.
I mean, we've never had a problem doing once a month. Harrison,
I'm concerned about the idea of a meeting to set up a meeting. I think that we do have a logistical issue here with if Richard is going to finalize the agenda that's going to be published to the rest of us, and we cannot privately communicate directly with him to provide input, there should be again, at least one staff member where we're providing our.
You can always provide,
Right.
The way I'm doing it is with Juanita. With Juanita.
yeah.
Juanita and I talk about it on the phone. And I give her my input on what's the agenda. We work very nicely. But I think that if you have input on the agenda, you could call Juanita and she'll.
My correct
do
you.
that.
That works for me.
That's the way we did it. It was a very collaborative, nice effort that we did. And, but if some other people have, you know.
The two people, did you collaborate independently? And then you collaborate independently?
All I'm saying is that the past when Harry Stewart was city attorney and there was a special thing like that. We would just do a public notice and two people because it was a special issue that that board member had. And with us designating someone to work on the agenda, it's just for the initial thoughts on it. And then Richard runs with it and works directly with staff on putting the final agenda package together.
Seems there we go, legal concern.
There's a legal concern, and in terms of the authority to do them. I'm not aware. of
Okay, we'll go
this.
find something that says it can't be done. In the meantime, Chris, do you want to just let Richard know the sections and then start working on that?
March, I have it, I think I just.
I'll take it. If you have it, I'll take it. And I have no problem. Sure, we are in the sunshine.
There's another consideration also, if they come to some kind of conclusion or agreement or,
It's not bad, it's just,
but wait.
What section?
There's also no forum, there's no, even the two of them meeting, what comes out of it?
I think you're making it more of what they're looking to achieve. It's just the idea of the section that they want to look at, and then Richard works directly with staff on compiling our final agenda package to be brought forward.
Listen, I don't want to create an issue here at all. I'm just trying to be helpful. So whatever you think, seriously, I'm not, this is not a,
So here's maybe an idea is at the end of each meeting, we just come prepared to talk about the agenda for the next meeting.
But that's what we did last month, and we said that that's exactly what we already did. We said this was going to be this meeting, we said it was supposed to be last month. Public lands were going to be the next meeting, and elections would be the meeting in June.
okay, so let me tell you what I would do if I was, what I would do is I
Yeah,
take
go ahead.
Chris's input. I know because I drafted with Kristen Jacobs, there's a Broward County charter provision that talks about public lands and businesses on public lands. I know that section 9 of the Dade County Home Rule Charter has a whole provision about public lands and talks about what you can use and what you can build and what kind of concessions can be there and all of those kind of things. I would try to find a couple other sample ordinances or charter provisions from other places that sort of talk about, that's what I would intend to do.
Matter, I compiled them a while ago. I compiled
Great.
the Dade, Broward, and City of Fort Lauderdale sections regarding public lands.
So why don't you resend me those again?
And there was another thing that I did at your request, which we haven't discussed, I don't know if you want to visit it. That is, which sections conflict with known statutory sections or county sections or what.
Which is why I thought that when we get to the month of June, we could be addressing all that.
Okay.
This is just dealing with the public land issue, which is
Public
a
land will
high
take a full meeting.
priority.
But then I'll just add that the one thing on that topic I would like to make sure we address, there is a limit of concessionaires only getting 1-year leases on public lands. I think that that is well intended, but not necessary. And I believe it merits some discussion. I don't know off the top of my head which section I saw it in, read through the whole thing today. Should have brought it down.
Okay. Well, you're gonna send me what you did before.
Yeah. That may be related to the city manager's authority.
Meriting discussion.
Yeah. So just so I'm tracking, so June 1st is the topic's public lands. Right? Okay. July 6th is elections.
Elections.
Okay, great. Do
And
we
then we'll,
know?
no, we'll take up after we hit those two and see which
August?
section we want to go next.
Okay. As I was looking at meeting,
One, and one of the other forms that, things that we discussed is eventually having a discussion on forms of government. Because that comes up all the time.
one of the things I noticed as I was looking at dates, 12/7 falls on Hanukkah, 12/7/23, so.
I already asked the city to put together a list of all the holidays coming up so that we know in advance.
Okay, yeah, that is, so we'll change that.
Yeah,
Some point.
they, yeah,
Once we
they
get
go
closer.
forward. They've already been asked to work on that.
Okay, great. And then meeting next month, June 1st, planned here. To be determined.
To be
determined.
We're working on that.
That's fine.
You'll have that in time tomorrow to be working.
Sounds great.
And just add 2 cents on that. While I know it's not necessarily the easiest thing for predictability, I think there is something nice about seeing all the different facilities that the city has to offer. And being in different parts of town so that members of the public can join us. So if it's
So you
not
can
here-
rotate almost, you're saying.
Right, if
Yeah.
it's not
Good idea.
here, I don't mind driving a little bit. City's kind of fun to see.
It's fun, isn't it?
Great. And then lastly, is this broadcast on channel 78, the public?
No, that's fine.
Okay.
YouTube only, once the infrastructure gets back up, it'll,
Then we'll be able to pop on. local.
yeah, but right now, YouTube
YouTube's
only.
great.
Yep.
Okay, thank you.
Okay, Cap Riley, this is a little bit different than the school board.
It is a little different.
And
There's a lot of
your role
similarities.
here is a little bit different.
Yeah.
You know, at the school board, the city order works with the superintendent. At the city, the city order works for the commitment. So it's a different role of governance. That's always interesting.
Move to adjourn.
To adjourn.
All there.